Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
Thank you for listening to this St. Louis on the Air podcast, supported by University College at Washington University, offering approachable world-class education with undergraduate and graduate programs, part-time, evening, and online. University College at Washington University.
Welcome to St. Louis on the Air. I'm Don Marsh. For 6 years, a case involving a Colorado baker has been bouncing around the courts after he refused to bake a wedding cake for a gay couple. He claimed it was contrary to his religious beliefs. The couple said it was discrimination. This week, the U.S. Supreme Court had what may or may not be the final say. It ruled 7-2 in favor of the baker. Here to help us understand the implications of the case is Anne Geraghty-Rathert, professor of legal studies at Webster University. She also directs the Willow Project. It provides legal assistance to female victims of injustice. Anne, thanks for being with us.
Oh, it's a pleasure. Thank you for having me.
We have a lot of territory to cover in a short period of time. Right. This court ruling was described as narrow. What does that mean?
Well, it's really an interesting case because the court could have gone in a variety of ways here, but they limited, almost sidestepped the main issues that were apparently before the court. And I think a lot of people were surprised by that. So what really happened was that the court could have talked about, free speech, free expression, artistic expression, could have talked more about the free exercise clause of religion, could have talked about equal protection, but instead it seemed to focus on the acts of the Colorado Civil Rights Commission in showing some outward hostility toward the religion of the baker. So this case doesn't really tell us much in terms of what precedent it sets. It really it sort of assures people that their rights are being taken seriously, both their religious freedom rights and their rights to not be discriminated against as members of the LGBT community, and also tells the government not to put their own sort of framework around religious freedom, not to dismiss other people's beliefs as unimportant or offensive or insignificant. And so in many ways, it doesn't really answer anything that anyone expected it would, but it does sort of set the stage for ongoing litigation, and particularly for anti-discrimination law.
A lot of people thought when they heard the ruling in favor of the baker, that this was going to open the door for any business to refuse to do business with gays if they chose to do so.
Right. And I think that, unfortunately, a lot of people are interpreting it that way because, when you hear that, one side won, as you do in a United States Supreme Court case, you sort of assume that all of their arguments are on the winning side. So you might assume that there is a religious exception to anti-discrimination laws. That is not what this case says in any way. And so many people, I think, are interpreting it like that, well, the religious community won, superseded the rights of the First Amendment, superseded the rights of equal protection and anti-discrimination. That is not the case. And so, all we really can get out of this is that the government cannot show hostility toward anyone's serious beliefs and can't dismiss them or consider them to be pretextual even.
Another part of this issue was the claim on the part of the baker that creative expression was at the issue, and that it was identified as free speech.
Yes. Yeah. So, within the free speech realm, it includes, of course, artistic expression. Again, though, the court doesn't really get to whether or not baking a cake is artistic expression. But the way the court has dealt with it in the past is a sort of a two-pronged test. If it falls within a traditionally considered expressive speech, such as poetry or music or paintings, those kinds of traditional things, then they say that the courts can't really interfere with the free speech rights of the individual. Baking a cake has never fell within that traditional role. So then you sort of go to the second prong of the test, which is whether or not the message is clear and concise coming from that. And so, again, they didn't reach that. They didn't get to whether, the baker's argument that baking a cake for a couple in this situation would be his speech, that it would be his artistic expression, and that people would receive that message as his endorsement and or celebration of that marriage. The court didn't get that to that point. That was the argument that clearly the baker was making, but again, undecided.
Another comment from the baker, he wrote that he wouldn't make a cake with an anti-American message either. Is this the same thing?
Well, I don't know that patriotism and religion are necessarily the same thing. I think that certainly patriotism can be a very deeply held belief, but it isn't the same as a religious expression or a religious belief. So I don't think those two things are necessarily analogous.
Yeah. He says that he was saying no to baking the cake, not to the couple.
Right, and that's kind of problematic, too. The courts have already sort of dealt with this in the realm of LGBTQ rights in prior legal cases from the United States Supreme Court, Romer versus Evans and Lawrence versus Texas, in which they essentially said you cannot really separate the status of a person as LGBTQ identifying from their conduct. In other words, the two are inherent to each other and, can't be separated. And that's what this baker was essentially doing. When the couple came into the cake shop, he didn't turn them away as a gay couple. In fact, he said that he would sell them any other bakery items, such as cookies, brownies, or even a birthday cake, but that specifically he wouldn't sell them a wedding cake because he believed it was an expression of his celebration and approval.
Well, he said, I think I have this right, that a wedding and a wedding cake are part of a religious celebration, and that's how it violated his feeling about religion and his religious rights.
Right, and I think he would at the time. It's important also to keep this sort of in a historical context, because in 2012, when this series of events occurred, we didn't yet have Obergefell, the United States Supreme Court case from 2015 that granted
marriage.
You're right, marriage equality for everyone. So this is 2012 in Colorado. So Colorado didn't have so-called same-sex marriage rights. And so this couple actually was flying to Massachusetts to get married legally because Massachusetts did allow marriage equality. And then they were coming back for their reception in Colorado with their friends and family. So that's what they were asking for the cake to be part of the reception. So it wasn't even part of the ceremony, which, might change things as well. But again, the Supreme Court doesn't really address that either.
Did the court punt on this issue?
Well, it depends on who you ask, I suppose. Yeah. But I think they did sidestep it. But in a way, they were careful to delineate what rights were for future cases. And in fact, Justice Kennedy wrote this opinion. He also wrote the opinion in Obergefell, the marriage equality case. And so he says at some point that, it's for future cases with different facts to elaborate on and clarify. But he clearly implies that, a state is entitled to have public accommodations requirements that are anti-discrimination. So the Colorado Anti-Discrimination Act was valid and included sexual orientation. So in the normal course of events, someone couldn't turn away a person based on their LGBTQ status in Colorado. But it was more this situation in which this person was claiming a religious exception.
So it did acknowledge in the ruling that there was a discrimination element to this case.
Absolutely. But it's sort of interesting because that is somewhat specific to Colorado in having this act. Not every state has it. Missouri, for instance, where we're sitting, does not have these kinds of specific protections for people, under Missouri law for employment or housing or public accommodations. But Colorado has a long history of anti-discrimination legislation, and in 2007 or 2008 added sexual orientation to that. And so people cannot turn away someone, from a restaurant, a hotel, a bakery. But in this particular situation, I think the baker was hoping to carve out a religious exception for his artistic expression.
Are you aware of any other cases that are out there that are on a path that could take this issue back to the court?
There is a case that specifically deals with a florist who turned down a gay couple that came in. And, it's unclear. I don't think it's as clear in that case that the person is necessarily using religion to claim that they have, an exception. So I think that'll be interesting. It may not be exactly the same set of facts in that it won't necessarily talk about free exercise of religion. But there are clearly other cases that are out there, having to do with videographers of weddings, even wedding halls that have turned down people. And so I think the fear is among the LGBT community and others who are concerned that somehow this is going to create a second-class status for people. So if someone, is entitled to marriage, but then they can't get a hall to have the reception or a cake or florist or whatever, it's sort of a slippery slope in which, people are continued to be regarded as somehow less than others.
The columnist George Will has a column out today that deals with this issue, and he says that expressive activities merit some constitutional protection, but not everything expressive is important as speech.
Right. And, I think that goes back to that same two-pronged test. Is this really artistic expression? It isn't the baker's speech necessarily, because when you commission a wedding cake, presumably you sit down and have a conversation about what that cake is going to look like, and presumably it's the couple that's controlling, the kind of cake and the type of decorations on it. So not every type of expression, first of all, is artistic, but then second of all, even as among artistic expression, I think this baker clearly considers himself to be an artist, but does the message come across clearly that the baker is the person who is celebrating the wedding?
Is there any danger of parsing the First Amendment the way this discussion is going and the way some people are looking at it?
Possibly. Certainly there's so much case law out there. We're almost inevitably headed toward this conflict because there's so many equal protection cases on the one end, anti-discrimination laws that exist in various states. Now the marriage equality law from the United States Supreme Court. And then on the other hand, we have all of these different pieces of the First Amendment, the right to free exercise of religion, the right to free speech, including expression and artistic expression. So I'm not really sure what the outcome of all that will be, but I think that, I think a lot of people who are religious and believe that there should be an exception are hoping that there will be a space in which they can perform their religious beliefs or not perform them, as the case may be, whereas others believe that anti-discrimination law is, predominant. We have had cases in the past, and in fact, this court in the case on Monday referenced a case, and I'm trying to remember the name of it. It's like Piggy. I don't know. It's from the civil rights era. Anyway, it was a barbecue place in South Carolina that the owner during the civil rights era with the 1964 Civil Rights Act claimed that not serving people of color, specifically African American people, was a religious belief of his. And the United States Supreme Court said, we're allowed to create fair and neutral laws that might impact on someone's religion if there is a compelling reason to do so. It's Piggy Park Enterprises. I just looked at it.
Okay.
So,
well, overall, the impact of this most recent decision is not that big.
I agree with that. And in fact, I think it is almost confusing in result. There have been people across the country who have reacted to it in varying ways by putting up signs in their places of business saying that they aren't going to serve LGBTQ people. Right. And so, there are, the ACLU primarily, but other organizations trying to pass an equality act at the national level that would ensure that people receive public accommodations regardless of their identity and orientation.
The story's not over, and you're right. It is confusing, and that's why we wanted you to be with us to help explain.
I think I'm confused too, though, so I'm not sure that.
Well, you helped me a lot. I'll tell you that. Anne Geraghty-Rathert, thank you so much for being with us, Professor of Legal Studies at Webster University. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.